Hello everyone, welcome to Lawfer. Today we will be discussing the topic Law of Torts, which is a very important topic for the upcoming CLAT UG exam, which is scheduled to take place on the 3rd of December 2023. I am Shirsho Ghosh and I am currently pursuing LLM from the WBNUJS. So let us look into a few important points, which is with us, you will be able to learn from the top NLU and IIM students. You'll have a complete course of the CLAT exam from scratch. We'll be having doubt clearing sessions, strategy sessions, practice sessions. You'll also have free sectionals. You can also opt for our various paid plans of mock tests, and you can also have choose your mentor plan, which is a one-on-one session. Now, directly moving on into our today's topic, that is tort. What is a tort? Now, tort comes from the word tortum, which means anything which is crooked, anything which is not straight. So, a tort is basically a wrongful act. A wrongful act, but this wrong is not a crime. This is a civil wrong. This is a civil wrong. So, basically, tort is a civil wrong. So tort is a breach of a duty independent of contract which gives rise to a civil cause of action and for which compensation is recoverable. And the person who commits tort is known as a tortfeasor. So there are various kinds of torts. For example, negligence. We will be discussing the various kinds of torts further, but just to give you an example, let's say I got upon a ride. Okay, in the amusement park there are various rides. I got upon a ride. Now, the person who is the operator of the ride owes a duty of care towards me. That is, if he is not taking sufficient care of the entire ride, let's say the ride is starting from this point, then the ride is going up and then it is coming down and it is again going this way. In this entire course, it is the ride operator's duty, ride operator's duty to take care, right? Now, if he does not take care, if he is not doing his duty properly, and that results in some sort of an accident, let's say here, okay, and somebody falls down or somebody is injured in that ride, then we will say that that ride operator has committed negligence. Okay, he can be sued. He can be sued before the court for the tort of negligence because his breach of duty has resulted in an injury to a person. So we'll look into the various kinds of torts. Now, before that, let us look into what are the essential elements or the constituents of a tort. It is a wrongful act. Okay, a person must have committed a wrongful act. For example, if we take this case, Sushil Ansal versus State, this is popularly known as the Upahar, basically the Upahar cinema case. Now, in Delhi, there was the Upahar cinema where there was a massive fire which killed so many people. Now, it was found out that in that cinema hall, there were no precautions, no fire extinguishers, nothing was present over there. Now, the Supreme Court, while deciding this case, had held that, all the uh, cinema hall owners where they owe a duty of care to all the people who are coming in their cinema hall to watch the movie. They owe a duty of care, and if they are not taking sufficient precautions, then they are guilty of tort. Okay, so this is the Upahar cinema fire incident where this case was held. This was regarding the cinema hall fire. Now, the second point which we have to keep in mind after the wrongful act. So first is that there is a wrongful act or a wrongful omission. Second is that there is legal injury. Now, what do we mean by legal injury? Legal injury means that a violation of a legal right. Violation of a legal right. Now, this may lead to actual damage or this may not actually lead to actual damage. Now, what I mean by that? please understand that you have certain legal right and that right has been infringed. That is known as a legal injury. Okay, this may lead to some monetary damage, this may lead to some physical damage, or this may not lead to any monetary damage or may not lead to any physical damage. What we are looking into is that there has to be legal injury. Okay, so here we will understand this concept by these two maxims: damnum sine injuria and injuria sine damnum. So damnum sine injuria means damage without legal injury. So actual damage has taken place, but there is no violation of legal right. That means there is no legal injury. Okay, so we will understand this with this case, Gloucester Grammar School case. So what happened in this case? Basically, there was a school. Okay, let's say A. There was a school A. Now, very near to the school, another school was set up, B. Okay, so what happened? Various students moved from school A to school B. Okay, various students shifted from school A to school B. Now the owner of school A sued the owner of school B, saying that the opening up of school B has led to loss or has led to financial losses as many students have shifted to school B. Now the court held that B is not guilty. Why? Because yes, monetary loss has taken place, school A has suffered financial losses, but no legal right has been violated because B also has the right to open up a school. So this has not infringed any of A's legal rights. So B is not guilty. Okay, this is the Gloucester Grammar School case. So this is damnum sine injuria. That means damage is there, but no legal injury is there. Now the second case is of injuria sine damnum. It means that legal injury is there without any actual damage. Now here we come across the case of Ashby versus White. What happened in this case? In this case there was a voter. Okay, there was a voter, and when that voter, let's say Mr. A, okay, Mr. A, he was a registered voter. When he was going to cast his vote, he was stopped. Okay, he was stopped. He could not cast his vote. Later on, Mr. A's chosen candidate only won the election. Okay, the person for whom Mr. A wanted to vote, that candidate only won the election. So now Mr. A still sued this person, let's say Mr. B, who had stopped A from giving his vote. Still Mr. A sued B before the court. Now B said that A has not suffered any actual damage because the person whom A wanted to vote, that person has only won. So A has not suffered any damage. But the court held that we don't care whether A has actually suffered any damage or not. It was A's legal right to vote, but that right has been infringed. Hence, A is entitled to get damages from B. So B was held to be guilty. Okay. Now the third essential element that we come across is legal remedy. The wrong is such for which there lies a remedy of civil action for damages. Now see, basically the wrong should be such for which there is a civil action for damages. Damages means compensation. It means compensation. Okay. Now, if you take, for example, murder, okay, somebody has murdered another person. Now, for that, you can't really give compensation, though nowadays we are moving towards victim compensation and stuff like that. But for crimes, okay, murder, theft, dacoity, robbery, for such things, we do not have an action for civil damages. Rather, we have punishment in criminal law. Okay, we have punishment. Okay, for example, the IPC talks about such cases. But in case of tort, we will not have punishment, but we will have remedy in damages. Okay, that is compensation. We move ahead now. The general defenses. Now, if you have watched the criminal law video, you will have seen that in IPC, in section 76 to 106, there are general exceptions, which are the general defenses of IPC. Similarly, in tort also there are general defenses. Okay, that is, if somebody is alleged, let's say Mr. P has sued Mr. D before the court. P is the plaintiff, D is the defendant. Okay. If P has sued Mr. D before the court, then D can take up any of these general defenses. Okay, D can take up any of these general defenses against P if the facts and situations are allowing D to do so. That is, if any of these are applicable to the case, then D can take up any of these general defenses. Now let us quickly look into what are these general defenses. The first one is voluntary non-fit injuria. That is, when there is consent, there is no injury. So suppose you have consented to suffer any injury. Later on, you cannot sue the other person as to why you have suffered that injury. For example, in this case, Hall versus Brookland Auto Racing Club, there was a car race going on. Okay. And one of the spectators who had entered that arena and who was sitting and watching that car race, he got injured as a result of an accident. Now he cannot claim any damages because such kind of an accident was ordinary, and when he was entering that stadium, he had given his consent. See, by entering any stadium, for example, if I'm entering a cricket match stadium today and if a sixer is hit and the ball comes and hit me, I cannot sue the batsman, because when I'm entering the stadium, I'm already giving my consent that such kind of injury can happen to me, right? So when I have given my consent, when that person who was watching the car race had given his consent, later on he cannot sue the organizers of the car race just because he had suffered some damages. So voluntary non-fit injuria. Okay. Second is statutory authority. If there is any statute, if there is any law which is permitting somebody to do something, then you cannot claim any tort. Act of God. Now, act of God or vis major, it is basically some kind of unforeseen unforeseen circumstance. Okay, unforeseen circumstances basically where you cannot really guess that something like this will happen. For example, there is torrential rainfall. Okay, there is excessive drought, or there is such thunder that a tree gets burnt up and the tree falls on your house and causes some type of damage. Okay, something which is extraordinary, we can say extraordinary. Okay, extraordinary, something like that happens, but you have to see that it has to be extraordinary depending on the situation. For example, let's say in a city like Kolkata or in a city like Mumbai, if in winter all the water pipes get frozen up, the water gets frozen because of extreme cold, that would be an extraordinary situation. But if the same thing happens in Kashmir, if the same thing happens in Himachal, if the same thing happens somewhere maybe in Arunachal or in the hilly areas of Uttarakhand, then that same thing might not be extraordinary, right? Because we have to see what is extraordinary and what is ordinary depending on the fact circumstances of the situation. Now next is necessity. Okay, when somebody does an act to prevent a greater harm. Okay, so greater harm has to be there, and to prevent such harm, if you have done anything, then that will not be a tort. Inevitable accident. Now here, if some damage has been caused just because of some accident which could not be prevented, okay, then once again that is a ground for defense. Now here we have the case of nitroglycerin case. So what happened was that certain carriers, they were carrying a box of nitroglycerin and there was some leakage. Okay, from this there was some leakage and the carriers did not know, the carriers were not told that what was inside. So what they did, they took this box to a building, okay, where the manager was there, and they asked him that, they told him that, see, this type of leakage was going on. But when this box was actually opened for inspection, there was a leak of this case which resulted in damage in this building. Okay, this building was only damaged. So these carriers were sued for this damage. Now here it was held that this was just because of an accident. The carriers did not intend to cause that damage, but it was an inevitable accident because there was leak and they did not know what was inside. Okay. Then is mistake of fact. Now, if there is any mistake of fact, if somebody has done anything under a mistaken belief, then that will be a ground for defense. But if there is a mistake of law, then that will not be a defense. As we all know that ignorantia juris non excusat. And finally, the right of private defense, which is present in section 96 to 106 of IPC. The same right applies in case of tort also. However, one thing which we need to remember if we look into this case is the rule of proportionality. The rule of proportionality. That means the defense should be proportional to the threat. The threat and the defense should be proportional. Meaning that if somebody is threatening me with bare hands, I cannot, in my defense, take up a gun and shoot him in the head. Okay, my defense has to be proportional to the threat. Now, what happened in this case, Bird versus Holbrook, was that a child was actually trespassing over certain property. Okay. Now, in this property, let's say this is the wall, and a child was trying to trespass on this property. Now, here, spring guns were set up. Now, as a result of these spring guns, this child was severely injured as a result of these spring guns. Now, it was held that, yes, the child was guilty of trespass, but the defense, which was spring guns, was greater than the threat of the trespass. So, the child was guilty, but so was the owner. Okay, so these are the various grounds of general defenses in tort. Next, we move on directly to the various kinds of tort. Now, as you know, firstly, tort can affect the body. So it is tort against body, which can be assault, battery, or false imprisonment. Secondly, we have tort against property, which can be trespass or violation of easement. Then we have tort against reputation, which can be libel, slander, or malicious prosecution. And finally, we have general torts such as negligence and nuisance. Now, to begin with, we are starting with assault and battery. Now, suppose there is a person, uh, let's say X, and there is another person, Y. Okay. Now, X raises his hand to beat Y. Mind you, X has only raised his hand. Okay. Till the point he has raised his hand to beat Y, this is an assault. Now, when he actually hits, this hand comes and hits Y. Okay, this hand, it comes and hits Y. Then we will say that that is a battery. So assault is a threat, whereas battery is actual use of force. Okay, so always we have to remember that assault is the threat of use of force, whereas battery is the actual use of force against a person. Okay, so this is the basic difference between assault and battery. Next we have false imprisonment. Now, suppose a person A has confined B in this space. Okay, this can be one room, this can be one house, or this can be one very tiny place also. Okay, but A has confined B in this place and A is not letting B come out. Now, this is known as false imprisonment. Why? It is not like it is false, but A does not have any legal authority. A does not have any legal authority to imprison B. because A is not a policeman. Okay, A without any legal authority, if he is confining B and B knows that he has been confined, B knows that he has been confined. So B's movement is somehow restricted by A. In that case, A has committed false imprisonment. So basically, when someone intentionally restricts another from moving, he is found guilty of false imprisonment. Next, we have the tort of trespass. Now, when a person owns a piece of land, let's say this land belongs to Mr. P, okay, and without authorization, a person, let's say T, enters upon this land, okay, without authorization, without permission, T enters upon this land. We will say that T has committed the tort of trespass. So we can say that trespass is an unreasonable interference with the enjoyment of somebody's land. Now, trespass can be of movable as well as immovable property, but basically here we are focusing on the trespass of immovable property. Next, we come to easement. Now, what is easement? Let us first understand. Now, easement is an equitable right. Okay, suppose there are two houses, A and B, and then this is the main road. Now, if you see the location of the two houses is, or the two pieces of land, let us say these are two pieces of land, the location of them is such that if from A somebody wants to go to the main road, that person has to cross B and then come to the main road. So the person who is living over here, let's say Mr. X, and the person who is living over here, let's say Mr. Y. So X has a right to go over Y's land to reach the main road. This right is an easement or an easementary right. This right is an easementary right. Okay, that X has to go over Y's land. Now, if Y stops X from movement, that is violation of an easement or violation of an easementary right. Okay, we move on to the next set of torts, that is falling under defamation, that is libel and slander. Now, always remember one thing: libel is to the eye, slander is to the ear. Okay, now what does that mean? First, understand what is defamation. Defamation means when I am publishing any statement which harms the reputation of some person. Okay, now what do I mean by publishing? Publishing means convey to any third person. Okay, publish does not mean that you have to publish in a newspaper. Okay, publish means that the person who is the tortfeasor, who is doing the defamation, the person who is, let's say, the aggrieved person, okay, who is the victim of the tort, and any third person. So a person who is making any statements which are defaming this person and any third person is hearing that statement, then that is publishing, that is defamation. Now, whenever there is publication of any statement which harms the reputation of any other person, that is defamation. Now defamation can be libel or slander. Now mind you that this differentiation between libel and slander is only present in civil cases. In criminal cases, whether it is libel or it is slander, it is criminal defamation only. Okay, which is there in under section 499 of IPC. Now libel is to the eye means it is in a permanent form. Okay, it is in a permanent form which can be seen. For example, any picture, any thing which is written down can be written on a newspaper, on any magazine, on any pamphlet. Okay, any movie, any recording, any video, okay, which can be seen, which is somewhere in a permanent form. That is libel. Now, what is slander? Slander is something which is in a transient form. That is, suppose somebody says something, spoken words, okay, gestures, something which is done once and gone. So it is in a transient form. It is somebody has heard something. So it is in a very transient form. There is no as such record of it. Okay, that is slander. So always remember that libel is to the I, because in lie I am saying I. Okay, if you just pronounce it in libel, I is there. So libel is to the I. And slander, it is ending with so you can say it's your. So okay, slander. So this way you can remember between libel and slander. Now let us look into the next tort, which is malicious prosecution. Now suppose A filed a case against B. Okay, A filed a case against B in the court, and ultimately in this case B won. Okay, that is the defendant won. And it was found that this case was filed out of malice. Okay, malice means ill will. Okay, hatred or ill will. And it is absolutely a false case which is filed just because of malice, and there is actually no ground of this case. It was an entirely false case which was filed by A. Now B can now sue A under the tort of malicious prosecution. So basically, when somebody files a malicious case against another person and it results in the victory of the defendant, then that defendant can file a case against the plaintiff that such case was a malicious case, and he can file for the tort of malicious prosecution. Okay. Next, we move on to the other kinds of torts, that is negligence, nuisance, and breach of duty. Now, negligence and breach of duty are kind of the same. So basically, as I said, that in negligence, what happens? That firstly, there is a breach of duty. Okay. So somebody owes a breach of duty to another person. As I gave you the example of a ride operator. Okay. So there is a ride operator who owes a duty of care to everybody who is getting up on that ride. Okay. Now, there has been a breach of that duty. So there was a breach of duty means there was a duty and there has been breach of such duty. That duty to do what? Duty to take care. And there has been a breach of such duty, and that breach has resulted in some damage. That breach has resulted in some damage. Then we will be saying that the act was a negligent act. Okay, negligence. Now here we have the landmark case of Donoghue versus Stevenson. Donoghue versus Stevenson. So what happened over here is that a person purchased a particular drink. Okay, it was an ale, ginger ale, and in that bottle, okay, in that bottle, they kept pouring the drink, okay, in a glass, and the person and her friend, they kept drinking it, and ultimately when this entire bottle, it was empty, when the bottle was emptied, it was found that inside the bottle there was a dead snail. There was a dead snail. So you can understand that here the manufacturer of this particular bottle, the manufacturer, he had a duty to take care. Okay, certainly, most certainly, he had breached his duty, because how was a snail found inside the bottle? And because of that, there were health hazards and damages which were suffered by the victims. So the manufacturer was negligent in this case, okay, which is Donoghue versus Stevenson. Next up, we have the tort of nuisance. Now, nuisance means some sort of annoyance or disturbance. Okay. Now, when there is a wrongful act and that wrongful act causes some sort of annoyance or disturbance, that is known as nuisance. Okay. So basically, we can say that nuisance is the interference within somebody's enjoyment of his or her property. Okay, so somebody has a right to enjoy his property, and when we are interfering in that right, that is known as nuisance. Okay, so for example, there is a road. Okay, now in this road, I have dumped certain things which have completely obstructed this way. Suppose huge logs, bricks, everything I have dumped over here, which has completely obstructed this road. Now, when certain persons are going in this road, let's say with a car, they cannot travel, so they have to take a detour. Okay, now this has resulted in damage to them because they had to maybe pay extra for fuel for this extra detour that they had to take. So this act of blocking the road, this act of blocking the road is nuisance. Okay, this act is called nuisance. Breach of duty, as I said, was same as negligence. Okay, now here I want to discuss few other important points, that is the different kinds of liability. So basically, after discussing all the torts, we can say that the various torts are imposing liability on the tortfeasor, right? That if the tortfeasor has done something wrong, then he is liable to pay damages. But there are certain cases where even if he has not done something wrong, then also he is liable. Okay. Or in certain cases, when somebody else has done something wrong, then also he is liable. So let us look into those cases. First, we will look into the case of no fault liability. No fault liability. Okay. This can be strict or absolute. Strict liability or absolute liability. Okay. Now, what is strict liability? Strict liability came up in the case of Raylands versus Fletcher. Raylands versus Fletcher. Okay. Now, what happened basically uh, was that there were two adjacent lands. Okay. And on one land, there was a mine, and on the other land, basically, a water reservoir was being constructed. Now, when this water reservoirs was being constructed, there certain channels were found out, but these channels were not sealed properly. As a result, when this water reservoir was filled, through these channels there was leakage and the water spilled over to the mine and the mine was entirely flooded. Okay, now here the court came up with the concept of strict liability, and this said that this person who was filling the reservoir, the owner of this land, will be liable. Although he did not intend to do any harm, still he will be liable. Why? Because of three things. Firstly, that he has filled this place with water, and water is likely to do some sort of damage to this place. Okay, so water is not a very safe thing to fill. Okay, so something which can cause damage, something which is dangerous. Okay, secondly, that there has been an escape. So firstly, we will say that there is a dangerous thing. Secondly, there is escape of that dangerous thing. Okay, so water had escaped to this land. And thirdly, there was non-natural use of land. Okay, so for example, he was building a reservoir over here. This was not a natural use. It was a non-natural use of land. So as a result, the owner of this land, he will be strictly liable. This is strict liability. Okay. Now, later on, our own Supreme Court came up with a doctrine which was stricter than strict liability, which is absolute liability. Now, in strict liability, there were certain exceptions. Okay, there were certain exceptions. For example, if there was natural use, if the damage was caused because of the natural user of the land, or if the thing which was filled in the land was not a dangerous thing. So there were certain exceptions. Okay. But in absolute liability, you can understand from the term absolute, it means that there is no exception. Right. So our Supreme Court in the oleum gas leak case, there was a very famous case of the oleum gas leak, which was MC Mehta versus Union of India. MC Mehta versus Union of India, 1987. Okay, you will see that there are various cases of MC Mehta versus Union of India. So you should remember the common name of this case. So this was the oleum gas leak case. Now, what happened in oleum gas leak case was there was a fertilizer factory. Okay, there was a fertilizer factory, and from these factories, there were certain gas leaks. Okay, there were certain gas leaks from these factories. Now here, the court held that we will not see whether it is dangerous thing or there has been escape or those things which we considered under strict liability. If there is any damage which is caused because of this hazardous substance which was being stored in the factory, any damage because of this hazardous thing, the owner of the factory is liable. The owner is always liable. Okay, so owner of the industry always has to be considered liable in such cases. That is the absolute liability. Okay, there is no exception to it. So these were the cases of no fault liability. And lastly, I will be discussing with you another kind of liability, which is known as vicarious liability. Okay, so what is this kind of liability? Let us check. Vicarious liability means that suppose X has done some, X has committed any tort, but for that Y is also liable. Okay, I repeat, X has done any tort, but for that Y is also liable. Now, can this happen? When can this happen? Generally, we say that when somebody is acting under the direction of another person, then the person who is giving such direction is liable. That is the basic doctrine of agency. That is the doctrine of agency. So when there is a principal who is giving actions to his agent, whatever the agent does, it will be deemed as if the principal has done it. It will be deemed, it will be considered as if the principal has done it. Okay. So in case the agent does any tort, the principal will be liable. This is known as vicarious liability. So with that, we come to the end of today's discussion. That was a complete lecture on the law of tort. I hope you liked it. Please reach out to us in the given numbers if you have any questions. You may also ask or put in your questions in the comment box. I'll be happy to help you out. And if you want to reach out to me personally, I'll be putting in the contact details. You can also reach out to me for any query that you have. Thank you.